Thank you so much. One of our very own here at the Norman Manley Law School. So it's safe to say that we have multi-talented students here with us today. All right. So we have come to the big moment, the moment when we will be hearing from none other than, I'm sure most of us, if you have went to UWI Mona at the Faculty of Law, you have admired this woman, this great woman, in my opinion, she is so able to break down any little thing on constitutional law. I will never forget how she was able to break down such complex concepts to me in my first year, and I'm so grateful to her and happy that she's here with us today. Of course, though, we will have the introduction for this great woman be done by none other than our very own Miss Suzette McNabb. Please make her welcome.
Good evening, ladies and gentlemen. Prof, you're smiling. Yes, Prof, you're smiling. Suzette. Yes, Prof. It is with immense pleasure and profound respect that I introduce our distinguished speaker for today. We are truly honored to have with us a legal luminary whose work has not only shaped academic discourse, but also has had a tangible impact on human rights and constitutional law across the Caribbean and beyond. I can personally vouch for this, as I had the opportunity to engage firsthand with the professor's depth of knowledge and insightful perspectives on both constitutional and family law. During my time at the UWI Faculty of Law, allow me to elaborate a little on her exceptional career. She's none other than Professor Tracy Robinson. She's a professor of law at the esteemed Faculty of Law at the University of the West Indies, Mona, where her interdisciplinary research delves into the critical areas of constitutional law, family law, human rights law, and the vital intersection of gender, sexuality, and the law. Professor Robinson is not merely an academic. She's a leading voice and a pivotal figure in Caribbean jurisprudence. Her co-authorship of Fundamentals of Caribbean Constitutional Law, now it's in its second edition, with the distinguished Arif Balkan and Adrian Saunders, speaks volumes. This seminal work, published by Sweet and Maxwell, is a cornerstone in the region, frequently cited in constitutional cases in no fewer than 10 Caribbean jurisdictions. Imagine the depth of knowledge and insight contained within a text, so influential. But Professor Robinson's impact extends far beyond the pages of this celebrated book. Her dedication to justice and human rights has led her to serve in crucial international roles. She was one of 3 experts appointed to the independent fact-finding mission on Libya by the UN Human Rights Council, a testament to her profound insights and impartiality. Furthermore, she contributed her invaluable insights as a commissioner on the WHO initiated independent review of equity and health inequalities in the Americas, thus demonstrating her commitment to broader social justice issues. Her expertise has also been sought at the national level, as evidenced by her membership on the committee, and I should say Caribbean level, on the Committee on Judicial Appointments established by the Law Association of Trinidad and Tobago. Adding to her already impressive portfolio, Professor Robinson served a significant term as a member of the Inter-American Commission on Human Rights, culminating in her presidency of this vital body in 2015. This is a truly remarkable level of engagement in the protection and promotion of human rights across the Americas. And my honored guest, I was told to make it short. She's so humble, but I have a lot to say. I hope you can see with me and let us go through. Recognizing her profound contributions to legal scholarships, Professor Robinson has been invited to share her expertise at some of the most prestigious law schools in North America. She has graced the halls of the University of Pennsylvania Carey Law School as a Buck Visiting International Professor in both 2016 and 2020, and has held the esteemed position of Distinguished Visiting Faculty at the University of Toronto's Faculty of Law in 2022. Most recently, in fall 2023, she served as a Global Professor of Law at the NYU School of Law. These visiting professorships underscore the international recognition of her scholarly achievements. In further acknowledgement of her outstanding contributions, Professor Robinson received the Prominent Women in International Law Award from the American Society of International Law in 2019. This prestigious award is a testament to her global impact and the high regard in which she's held by her peers. Therefore, everyone, please join me in extending a very warm welcome to a true leader in legal thought and human rights advocacy, Professor Tracy Robinson.
Thank you, Suzette. You know, after all of that, I am like my grandfather, like my mother, I'm just a teacher. So before I begin, I'm going to beg a little IT help. The teacher in me has a PowerPoint, and I know I am to have a clicker for it. But while they figure that out, I want to acknowledge the President of the Caribbean Court of Justice, Senator Scott Motley, Dr. Ilambe Motley, senators and parliamentarians, Solicitor General, a classmate, acting principal, also my classmate, many distinguished guests, the teachers and students of the Norman Manley Law School, several of whom were at some stage on the other side of the road. And I also acknowledge the sisters of Cecil Dennis Morrison, who are with us, Petrona and Anthea Morrison, today. Friends, family, good evening, or maybe it's on the edge of night by now. So thank you, Norman Manley Law School, for the invitation to deliver the Norman Manley Distinguished Lecture and the opportunity, of course, to mark the 20th anniversary of the Caribbean Court of Justice. I didn't appreciate that today was the day. Norman Manley, as you heard from Senator Scott Motley, is a central figure in my area of work, Caribbean constitutional law. He has had an outsized influence on Caribbean decolonization constitutions, and I'm honored to deliver this lecture in his memory. It's been an opportunity for me to also remember my grandfather, who greatly admired Norman Manley, Teacher Robinson. He was a campaigner from 1944, when most of us, people who looked like me and you, gained adult suffrage in Jamaica. He represented Western Westmoreland. Yes, that's the constituency in the news. He was in Parliament in the period which the senator mentioned between 1959 and 1962. I'm reminded in your account to Senator about the diversity of views which existed at that time, including in the People's National Party. He was a very strong Republican. And he taught the teachings of Marcus Garvey in primary schools, which he had responsibility for. A reminder of what Dr. Barnett says about the profound impact of Garvey on West Indian political thinking through his advocacy of principles of racial equality, of Black consciousness of self-determination, and popular democracy. In 1947, at the Caribbean Labour Congress in Kingston, which had at that time great leaders present, T.A. Marichaud, Hugh Springer, V.C. Byrd, Albert Gomes, and Grantley Adams, Norman Manley gave what was by all accounts a rousing speech about West Indian unity being vital to our progress. He said with prescience, given the fate of the West Indian Federation, which failed, and to which he had been so integral, he said, "I affirm that great causes are not won by doubtful men." He said, "I affirm it's the duty of West Indian leadership to know what it wants, to be in a position to lead the people forth in unity once able to decide that a cause is vital to its progress." Manley was absolutely correct that great causes are not won by doubtful men. But one of my lessons of the last 2 decades of the CCJ is that great causes can still chart success in spite of or, and probably also because of our hesitancy or apprehension or questioning, as these strengthen our institutional development and as the institution's resilience communicates back to the questions we've been asking and produces shards of new understanding. The haste and quiet, which you also mentioned, of our independence movement has led us to ask the famous question Simeon McIntosh did: are these products really our own? But that's not a question we ask of the CCJ. Yet we sometimes feel overwhelmed by the noisiness of this part of our history, and as we're filled with impatience and tempered by the doubts. Yet, in a region where, to quote President Saunders, difference is as natural as breathing, we might want to reflect on the noisiness of the progress as the kind of noise we would have in the procession of a loud Carnival Monday. We start in different places, as we would in the procession. We wear different costumes. Some of us are playing mass, some of us are spectating. We're chipping, we're whining, we're liming. We are transformed along the way and loving that this is ours. Despite the diversity of our experiences that day on the road, we would say, is ours. We are going more or less in the same direction. And our plural and diverse and noisy journeys are our own. Peculiarly then, as we celebrate 2 decades of this court, I want us to acknowledge with less antagonism the noise of failed referenda, the noise of constitutional reform that will not take us there. And I want to say something about the noisiness of the court itself as something we should mark as part of its progress. Tom Poole and Sangeeta Shah describe a noisy court as one with lots of separate opinions, which is true of the CCJ and its appellate jurisdiction, and especially true in the area I work in, constitutional law. There's a trade-off in some certainty. When you have noise, some fuzziness is engendered. But as Poole and Shah point out, the noise can signal that decision-making is open, it's discursive, that judges are contending with each other, they're reflecting over time on their own views, they're willing to be wrong, as Justice Burgess put it in an interview last week. And they cite a former ICJ judge, Hirsch Lauterpacht, and his book on the development of international law by the International Court. He argued that separate and concurrent opinions made a beneficent contribution to the development of international law and the authority of international justice. He said it would be prejudicial to the cause of international justice to assume that the weight of the court's decisions is irrefutably entrenched behind its formal authority. He added that judicial differences, the noise in the court, is indirectly a powerful stimulus to the effort of which a tribunal is created. And so this fledgling court in a discordant region with strong diversities of views in the court and about the court, that it invites us to disinvest from the notion that success demands absolute quietude, universality, or unqualified consent or contentment. The late Camille Brathwaite described noise as that decorative energy that invests the nation's performance, unnecessary, but without which we would not be enough. Sometimes, especially in this part of the Caribbean, the Northwest, we talk about the CCJ as if it's still an ideal, as if we still are get ready, not acknowledging it's a formed institution. In fact, in my estimation, the CCJ is the most studied Caribbean institution in the last decade. So I'm now discovering, all right, I'll figure it out with your help, which part to click, so I haven't asked for the clicker. And so I also, okay. I mean, the other alternative, I can just tell you when to go to the next slide, so we won't be interrupted. In addition to the misapprehension we have of talking about a court as if we're still thinking about it, we often talk about the CCJ in these parts as if it's an inscrutable place down south. Yet one of the reasons why it is so closely investigated is that we want to discern what we might learn or be able to gain precisely from that southern turn in the work of an international and supranational court. Some of you know the significant body of literature that accompanied the creation of the court in the noughties. Caribbean jurists and public intellectuals, including the late Duke Pollard, Sheldon MacDonald, Delano Franklin, Sir David Simmons, Sir Hugh Rollins, Dr. Kenny Anthony, Professor Rosemary Antoine, a new book by A.J. Nicholson. Prominent Caribbean jurists have surveyed the work of the court at key moments. These have included Pro Vice Chancellor Antoine, Dr. Barnett, thanks so much. And then you have the work of the judges themselves on the jurisprudence, and by the 2010s, a second tier of literature on the CCJ emerged. That literature scrutinized dimensions of the work of the new court, its decisions in both the appellate and the original jurisdiction, in case notes, in textbooks, including by our two international law professors at the UA, Professor Stephen Vassiani and Professor David Berry. On aspects of the original jurisdiction, you'll see contributions by Vincentian scholar Dr. Jason Haynes, by Derek O'Brien at Oxford Brookes, by Ria Mohammed Davidson from Trinidad and Tobago. On the regional project from Professor Michelle Scobie. Other very distinctive contributions include analysis of the CCJ's 2020 decision on the Guyana elections, including by the university's best experts on constitutional governance, Professors Hamid Ghani and Cynthia Barrow-Giles, and my Cave Hill colleague, Dr. Ronnie Yearwood. I've noted that several PhDs with strong focus on the court have emerged. They've come out of University of Chicago, University of Roehampton, University of Copenhagen, George State University, and an ongoing PhD at the University College London. Remarkably, these are interdisciplinary studies in political science, anthropology, and law. Okay, so another attempt. Can I just ask you if I can cue you, that's perfectly fine too. And then in the last 5 to 7 years, as the court continues to build this body of distinctive work, there's an ever-expanding literature assessing the court, its effectiveness, its legitimacy, its jurisprudence. The methodologies of these studies, which include interviews with judges and ethnographic study of the court at work, reveal how accessible the court has been to researchers. There's a new book coming out of Trinidad and Tobago by Indira Rampasad and Anthony Gafoor, just published on the jurisprudence of the court. My colleague Gabrielle Elliott Williams has been writing about the decolonial ethic of the court. Jamaican Professor Seshona Wheatle and Dr. Unique Campbell have been analyzing favorably its creolized jurisprudence. Then other work evaluates the CCJ comparatively. Belizean academic Harold Young has a book looking at the CCJ and the Privy Council. Danish scholars Salvatore Caserta and Mikhail Rask Madsen have written extensively about the court's regional integration project, its human rights jurisprudence, and made comparisons with other international economic courts in Latin America and international courts generally. Thanks. If you turn again, you'll see other UA scholars working on the CCJ, and again, until slide 7. Thanks. Despite the attention given to the work of the CCJ, I think there's one area that has been less considered, except by a few political scientists, and it's the relationship between the CCJ and our political processes and its role in safeguarding a core constitutional principle, that of democracy. I can think of a few reasons why that kind of conversation has been so muted, the talk about courts and democracy, and I want to focus on 2 of those, and that may be the next slide. And to tell you a little bit about how the CCJ, the next one, has responded to both. Slide 7. One is a worry, yes. One is a worry that democracy talk and judicial review may be mixing oil and water, an inappropriate conversation. And by that I mean there's a worry famously articulated by the American Alexander Bickel, that there's a counter-majoritarian difficulty with judicial review, that the unelected judicial branch should not assume an expansive role in the process of reviewing what Parliament has determined and decided, and in telling us what democracy should look like. The second reason is that we avoid this discussion partly because we're looking in another direction. We think of ourselves as Westminsterites. We think of ourselves as West Indians with durable constitutions and stable democracies. In other words, we don't really have a democratic issue. After that, I want to say something about what I think are 3 very useful ideas I hear emerging from the CCJ's work. I think the court's jurisprudence has sharpened our thinking of not just the value of democracy, but a democratic culture. I think the court is pushing us to ask what it is we associate with democracy, and do we associate self-determination? And I think the court is usefully situated itself in a space of not just ruling, but as an institution engaged in constitutional dialogue. Dialogue with other judges, dialogue with other branches. We can go back, all the way back to where I was before. Thanks. But let me turn to the question of whether constitutional court should be in the business of safeguarding democracy. Should the judiciary be contributing to what we think democracy means? Or should this be left up to the democratic processes, or parliaments in particular? Canadian Rand Herschel's language is the language of juristocracy. He has a deep worry about what he calls the pervasive judicialization of politics. He sees it as dangerous to our democracies. He says we have emerged in a moment in which courts have become major political brokers and decision makers under the constitutions across the world. And I want to be quick to acknowledge that judges must tread carefully and sometimes lightly in political cases. But we can't forget that it's the constitutions themselves that ask courts to be critical arbiters in political disputes, namely in election petitions and disputes about who qualifies to be a member of our parliaments. But also, it is our constitutions which delineate the plenitude of state power. They create the apparatus for our political lives, where there are disputes about what the Constitution means in respect of these provisions, when we are asking questions about whether those provisions have been properly amended, we can't be surprised that constitutional courts come into play. Even where our constitutions direct the swift resolution of electoral matters by specified courts, it's still for constitutional courts to clarify, if disputed, who has jurisdiction to do what. The bottom line is that the counter-majoritarian difficulty with judicial review, the worry about growing juristocracy across the world, both north-centered critiques are no match for the accretion of authoritarianism and what some have called democratic backsliding. One global report on the state of democracy for 2024 found that 47% of countries in the world experienced a decline in key democratic indicators over the last 5 years. In 2024, 1 in 3 voters, they say, lived in a country where the quality of elections had declined. The report found that electoral participation has been declining, and at the same time, elections are increasingly disputed. And they note even the so-called high-performing countries have also experienced significant deterioration in democracy. And so in 2020, as we watched the results of the Ghana March elections go undeclared for 5 months, as the incumbent government disputed the results, which appeared to indicate that it had narrowly lost the presidency and a majority in the National Assembly. The chief electoral officer refused to properly submit the results of a recount and arrogated to himself the power to subtract votes he deemed irregular. As we watched all of that in 2020, some of us were not talking about the counter-majoritarian difficulty of courts' intervention. We were worried about what would happen to our institutions if the CCJ did not intervene. And not the question of whether this court was exceeding its institutional role. It is in this context that tens of thousands of us across the Caribbean and further afield watched live proceedings of the CCJ on the 8th of July of 2020, a week after the court heard arguments in the case before it. And it delivered its unanimous decision in Ali and David in what turned out to be the most serious political crisis which it had been asked to intervene in. Just about every news media in the English-speaking Caribbean carried the outcome. The CCJ ultimately granted special leave to appeal to it and said the question about the proper interpretation of the Constitution was a matter for it as the final court of appeal. It relied on fairly conventional legal analysis. It concluded that, again, a court of appeal had improperly assumed jurisdiction in the matter. It had sought to exclude the CCJ, and it had trespassed on the exclusive jurisdiction of the High Court in electoral matters as a trial court in constitutionally mandated and evidence-based open justice, as they put it. The contestations about the results or properly to have been brought before the High Court, which they ultimately were, and disposed of by Chief Justice George. The CCJ hardly solved Guyana's problems in that moment, the region's most fragile democracy, but its judgment led to the declaration of the results, which had been held up for 5 months, and the formation of a new government within a month. Let me quickly turn to the second reason we don't often talk about democracy as constitutional lawyers. If you read Caribbean constitutional cases from the 1960s, the 70s, the 80s, you almost never hear the word democracy as a constitutional value, even though most of our constitutions, Jamaica is an exception, declare that they're sovereign democratic states and deeply entrench those provisions. In a famous 1967 case, Thomas and Forrest, Justice Smith concluded that, as we know, the Bill of Rights then had no right to vote, but he said it could not be implied from the chapter which provided for the creation of Jamaica's democratic institutions. As late as 2002, the Bahamas Court of Appeal similarly concluded that the right to vote in the Bahamas was statutory and not constitutional in Ingram and McEwen. While Ralph Carnegie asked, how can one rationalize the existence of a constitution which entrenches so much of its content but doesn't include a provision about the right to vote? In other words, he's saying this is a matter for reform, as indeed it was, and addressed in 2011. But for the Eastern Caribbean Supreme Court, it was a matter of constitutional construction. The Eastern Caribbean Court has in several cases identified the right to vote as part of, to quote them, the very fabric of our parliamentary system of democracy. And similarly so has the CCJ. Justice Jamadar has, for example, talked about free and fair elections as part of the deep structure of Dominican constitutionalism, and integral to that is the right to vote. We've been muted about what our constitutional commitment to democracy means because we are looking in a different direction. We are looking to Westminster. We are using Westminster as a heuristic of a sort to figure out what our governance arrangements are or should be. You remember in Hines, the Privy Council pointed out that the Jamaican Constitution left a lot to necessary implication. And how did you fill out the gaps? Every constitutional law student knows this. You look to Westminster. They were, Lord Diplock famously said, negotiated as well as drafted by persons nurtured in the tradition of that branch of the common law of England that is concerned with public law. And those men are familiar, he said, with the concept of separation of powers as it has developed in the unwritten constitution of the United Kingdom. He was certainly thinking about men like Norman Manley, probably a lot less so men like my grandfather. Justice Witt, the late Justice Witt, in his first big constitutional case in 2006 from Barbados, Joseph, Justice Witt, you may know, was Dutch, and he said he was surprised that we were still referring to our constitutions as Westminster Model ones. He said this largely unwritten English constitution, shaped by conventions and common law, seems to have been set in ice in all its perceived magnificence and splendor. And then Prof. Carnegie, the first teacher of Caribbean constitutional law at the UWI, said in response, when we speak of our Westminster model constitutions, we are not being lawyers. We're not even being political scientists. We're at best being poets. One difficulty is that the Westminster model as a heuristic is morally neutral. It can tell us what we supposedly follow. And as Carnegie says, that's not factually correct in many cases. But it doesn't tell us what we believe about democracy. In an era of democratic backsliding, this heuristic comes up empty. As we saw in the Trinidad Tobago Chandra Sharma case, which was produced in the 2001 constitutional crisis when both major political parties got 18 seats in the lower house. President A.N.R. Robinson, as I would have to say it's not unusual that this happens, appointed the incumbent as prime minister. He in turn appointed several of the persons from his group of 18 in the lower house to his cabinet. The parliamentarians will know exactly what that meant. It meant that there could be no speaker appointed in Trinidad and Tobago, no one could be sworn into the lower house, none of them got paid, except those on the government side who were cabinet ministers and paid as cabinet ministers. Lord Bingham had to figure out, well, is there a rule, a principle, a practice, a convention at Westminster which can help me resolve this problem of this inequity between the two sides in Parliament? He scoured British parliamentary procedure and came up with nothing. This problem had never arisen at Westminster. There were no British political conventions to guide the London-based Privy Council in its interpretation of this so-called Westminster Model Constitution. Instead, he ended up implying a right for parliamentarians to be paid once they were ready to take the oath from what he deemed to be a core constitutional value. This is not Westminster, though. It is that the framers of the Constitution intended the parliamentary system to operate in a way which, subject to the constraints of democratic choice and adversarial politics, is fair and even-handed between competing partisan interests. Justice Whitting-Joseph notes that there is still perhaps understandably an inclination, to quote him, to take the English common law as the point of departure for Caribbean constitutional law. And he said that he hoped and he envisaged that these flashes of enlightenment will be taken to their ultimate conclusion, so that, in other words, we must end it, so that a genuine constitutional law will be developed on the basis of Caribbean constitutions themselves as the embodiments of democratic societies they wish to establish and they wish to guard. He says the English common law in Westminster is not irrelevant, but it absolutely cannot be the centerpiece of Caribbean constitutional law today. The unpoetic truth is that saying we have durable Westminster constitutions that generate regular elections leaves us wholly unresourced to address the cacophony of democratic dysfunctions we experience. Manuel Jose Cepeda Espinosa and David Landau describe what countless Caribbean political scientists have, that in our notional constitutional democracies, when incumbents gain power, they set about through formal and informal mechanisms to stay there. Notice the uncommon interests. Notice the uncommon interests of incumbents. And I want to offer the caveat that I'm not speaking directly to you, Mr. Jackson. But there's an uncommon interest of incumbents everywhere in the world to have responsibility for elections and determining constituency boundaries. When a constitutional ouster appeared to be a sword used by the governing party in St. Kitts and Nevis to prevent scrutiny in the courts of changes which the governing party had sought to boundaries, the Privy Council correctly pointed out that it had to assess that ouster in light of other constitutional provisions that entitled us to due process and access to the courts. A decade before that 2015 decision of the Privy Council from St. Kitts and Nevis, the CCJ had explained that a democratic system established under the Barbados Constitution could not contemplate, ouster or no ouster, zero accountability for someone who was a designated decision maker in our governance system. Some have used the term competitive authoritarianism to describe the patterns of governance in which the incumbent has created an uneven playing field in their favor, and it is no longer possible to say the regime is fully democratic, or in some cases even that the elections are fair. In the Caribbean, where we still have some government-owned or controlled media, competitive authoritarianism involves limiting access to state-controlled media. It involves the suppression of dissent and protests led by opposition figures, or using periods of public emergencies and public order legislation to criminalize those who disagree. We have seen the regular use of defamation suits to shut up the voices of those who threaten our political futures. Except in the case of Tim Hector in 1990, the Privy Council has been fairly tepid about these kinds of violations and these threats to our democracy. But when Justice Saunders was sitting in Anguilla, where a program, Talk Your Mind, moderated by a man named Benjamin, was removed from the government-owned Radio Anguilla after the program had critical content of the government, he found a breach of Benjamin's right to freedom of expression and the right to freedom of expression of those who listened to the program and contributed to the program. He accepted that Benjamin had no legal right to have this program, but he said he had a legitimate expectation that the program would continue unless there was a very strong public interest in its suspension. His judgment is replete with analysis of the importance of freedom of expression to democracy. And he actually recommends to Anguilla that a board be created for this government-owned radio station so that it can be free of the political directorate in its day-to-day affairs. The Privy Council affirmed his decision, but said virtually nothing about the significance of the breaches for democracy in this tiny overseas territory. Competitive authoritarianism is a form of political accumulation that includes abuse of state resources, clientelism, corruption, all of which are used to bolster electoral results. Sometimes, in parts of the Caribbean, these efforts are used to manipulate electoral results. Dare I mention the places where flights appear? This is not one of those places in time for election day, so that persons can vote. These patterns, it gives new meaning to, for those of us who are old enough to remember the 4 flights a day. Well, multiple flights appear. Five flights a day. Well, in very small jurisdictions in parts of the Caribbean, multiple flights appear of potential voters on election day. In Scarrett and Defoe, the CCJ held it was open to a magistrate hearing a criminal complaint for the offense of treating, which had been filed in respect of government MPs who were alleged to have used free public concerts to corruptly influence the electorate on who to vote for. There was an argument that this jurisdiction of the magistracy interfered with the High Court's original jurisdiction in election petitions, and the CCJ disagreed. Both could proceed. In Marin, a Belizean case, the CCJ had to evaluate whether the Attorney General of Belize could use the common law tort of misfeasance in public office in respect of 2 former ministers alleged to having been engaged in corrupt practices. The dissent of President de la Bastide and Justice Saunders at the time asserted that it could be hardly disputed that the failure to detect, investigate, prosecute, and punish corruption has a corrosive impact on democracy and the rule of law. Professor Ralph Premdas reminds us that elections are a necessary feature of democracy, though in Ghana he explains, and I quote him, "They are the period where the greatest harm is done to social cohesion, as competitive parties in the quest for electoral votes deepen the divisions in the social system." He adds that party competition during the electoral contest accentuates intersectional suspicion and hostility, weakening the integrity and stability of the political system. Dynamics differ across the Caribbean, but this is not just a Ghana story. The next slide. With systems of already strong prime ministerial control across the Caribbean, the consolidation of incumbency can produce what I've called in the context of the COVID-19 pandemic, kingification, where our leaders become like kings. Populist, strongly personalized big man leadership becomes very heightened in crises. The next slide, thanks very much. Where oversight from the other branches becomes limited. And in the next slide, in the Belizean case of BCB, the Belizean government established a bespoke taxation agreement for certain corporations. And the CCJ made it clear that this interfered with the Parliament's responsibility for taxation. That responsibility could not be delegated to a private group of persons in the executive. Then Justice Saunders noted the operation of what he called prime ministerial governance, the paucity of checks and balances available to restrain an overweening executive. He says these are the malignant tumors that eat away at democracy. No court can afford to encourage the spread of such cancer. The malignant tumors warrant surgery, constitutional reform. But the CCJ has said we cannot simply send the patient home, indifferent to the spread of the cancer, or duty to uphold the Constitution. The court's job is not to cure the cancer, but the court can contribute to the diagnosis in constitutional terms. It can discourage the spread. In the case of Mustafa, the CCJ had to interpret the complex consensual system for the selection of the chair of the Ghana Elections Commission, the supervisory body for elections. That person is appointed by the president from a list of 6 persons who are not unacceptable to the president, submitted by the leader of the opposition after meaningful consultation with non-governmental political parties represented in the assembly. If the leader of the opposition fails to provide the list, the president can appoint a suitably qualified person, and the person should be a former Superior Court judge or another fit and proper person. As you can imagine, there was a dispute about who should be the chair of GCOM for the very reasons which I have mentioned about the ways in which electoral bodies become central stages for some of the democratic dysfunctions we see. The court's majority concluded that they saw a way forward for Ghana in which the president would signal before the formal presentation of the list that particular listed nominees were not acceptable to the president. This signaling mechanism would allow the president and the leader of the opposition to get closer to consensus quickly. This informal signaling procedure before the list is actually submitted is what I would call a strong form of judicial review. There's a gap in the constitutional regime. There had been deadlock in the decision to choose a new chair for GCOM. It's a kind of quasi-legislative role we've seen the Indian Supreme Court adopt in cases was it appropriate here? When you take into account the chronic dissensus of the leaders in Guyana, when you assess how integral to democracy this appointment was, the seeming willingness of the leaders as well to do what the court was suggesting, the answer is yes. The two leaders complied with the directions, and the highly respected former Court of Appeal Judge Claudette Singh was appointed the GCOM chair, and she oversaw the fateful 2020 elections in which GCOM ordered a recount of some votes that gave rise to contestation and litigation. Like Mustafa, the CCJ in RAM was asked to properly construe what the Constitution means. And here in 2019, the court gave a decision on a vote of no confidence in December of 2018. The APNU AFC government at that time had the thinnest of majorities. Of the 65 seats, they had 33 to PPP Civic's 32. PPC Civic called for a vote of no confidence. There could hardly have been a more dramatic parliamentary sit-in. As a government parliamentarian, and I see my students who could act out this bit, which you will hear, government parliamentarian Charandas Prasad voted yes in favor of the vote of no confidence, turning the tables on his government. So this may be the next slide. And if you press play. You may hear some of them. Okay, so let's see if we can get sound. So grateful if you go back and see if we can resolve the sound. So what you're going to see first is that they are calling for the votes on the side of the opposition. You'll see familiar figures. You will see the then leader of the opposition, Barrett Jagdeo. You'll see the now Attorney General and ministers. We still have no sound. Just hold it for a second and see if we...
Yes.
Okay, so can we just go back to the start and maybe turn up the sound a little bit? So we're on the government side.
Mr. Lumumba. Aye. Mistress Pauline Sukai.
Yes.
Dr. Anthony.
Yes.
Ms. Manik Chand.
Yes.
Mr. Nanlal.
AG,
Mr. Ali.
Yes.
President,
Mr. Shira.
Minister.
Yes.
Mr. Rohi.
Yes.
Mr. Jagdeo.
Yes.
All saying yes, no confidence. Switching to the government side.
Mr. Rutherford.
No.
Mr. Raj Kumar.
No.
Mr. C. Prasad.
Yes.
Mr. Tamira.
He's on the government side. He's saying yes. So watch his colleagues. He gets several elbows.
No. No. Correct yourself. Correct it. No.
Yes.
No.
So David, when you're in class, you used to do no charandas, no.
Mr. C. Prasad.
No.
Mr. C. Prasad.
No. No.
Mr. Charandas Prasad.
You can vote again. Say no.
All right. You know, you get the picture. Then the incumbent, the government, APNU AFC, offered an inventive argument that a majority of 65 parliamentarians was half of 65, 32.5 plus 1. So that's 33.5, and you can't have half a person, so you round it up to 34. I see my Aunt Judith looking at me in bewilderment. The young people would say the math's not mathsing. The CCJ quickly set aside the Court of Appeals majority decision that had accepted this reasoning and quickly concluded that 32 was a majority of 35, restoring the Chief Justice's ruling. In the next slide. In all of these cases, I would argue the CCJ enters the arena as a constitutional court, offering an analysis of the normative framework, that is the constitutions, their strong commitment to democratic governance, looking at their duty on the Constitution to assess what's constitutional. I would argue that they introduce an evaluative element, a response that doesn't dismiss Westminster but has doubts it's going to give us the answer. And they introduce some measures of accountability. They seek to diagnose the difficulty in constitutional term and figure out what can the court do. We see these normative, evaluative, and accountability frames at work in the case of Cedric Richardson in the term limits case in 2018. There'd been a constitutional amendment in 2020 which introduced term limits for the Guyana president. The president at the time was Barrett Jagdeo. But in 2014, a citizen, Cedric Richardson, said the new term limits violated his democratic right to choose who he wanted to be president. He wanted the person who had already served 2 terms and was ineligible, Barrett Jagdeo, who had overseen these reforms, to be eligible. And he said that this infringed the fundamental principles of democracy in the Constitution. He argued that the provision relating to democracy in the Constitution was very deeply entrenched, the one relating to the presidency a little less entrenched, and if we wanted term limits, you had to alter the provisions relating to democracy, which required referenda. Justice Saunders said, these articles about sovereignty and democracy express normative values. Interpreting them requires the court to adjudge their content in the round in a holistic way. Any assessment of whether, and if so, how they are implicated by an act of parliament must take into account the historical and surrounding context. He said, in my view, the Republic is either to be adjudged to be worthy of the description Republican sovereign, or the amendment has taken it outside that classification. As long as the country is governed by a constitution based on the rule of law, that constitution requires impartial and independent courts ultimately to make that judgment. Context mattered. President Byron paid close attention to the history of the constitutional reforms on term limits. They also looked outwards, concluding that an untouchable voter choice is not a feature of democracy anywhere. In thinking about what are appropriate judicial interventions, I hear the CCJ in several cases saying, look at our context. In a different case, slightly different environment, I hear Chief Justice Sykes saying the same thing in the NITS case. He had been told, why aren't you showing more deference to the political branches as policymakers and legislators? And he said, the road to state control of the lives of persons usually begins in small, imperceptible steps. It is usually clothed in the garb of some greater perceived good, such as national security, economic growth, and the like. There begins one slight trespass, and then another, and another, and before long, the trespass becomes the norm, and the right the exception. He says, the citizenry of Jamaica looks to the court to hold the line and to enforce the Constitution. He says, the courts don't make the policy, but the court cannot shirk their role by hiding behind the principle of deference. I want to very briefly, as I come closer to the end, to highlight 3 dimensions of the CCJ's work and jurisprudence that may be shaping notions of democracy and courts in the Caribbean. Responding to what Michaela Heilbronner describes democratic malfunctions, but also offering ideas on how we can optimize democracy. The first I discern is its read of Caribbean constitutions as promoting not just democracy, but democratic cultures. The second emerges from the Savings Law Clause jurisprudence, which I think has interesting ideas about self-determination and democracy and self-government. And finally, to say a word on what I hear as its invitation to constitutional dialogue, not just to judging. Jack Balkin defines a democratic culture as a culture in which individuals all have a fair opportunity to participate in forms of meaning-making that constitute them as individuals. Democratic culture is about individual liberty, but it's also about collective self-governance. It's about everybody's ability to participate in the production and distribution of culture. A democratic culture is a culture that allows not just elites, not just the toponaris to have a fair chance to participate in the production of culture, meaning in the development of ideas and meanings that constitute them and the communities to which they belong. I sense we're beginning to see from the CCJ the articulation of a democratic landscape in which our democratic cultures matter as much as our democracy. President Saunders in Mustafa, the GCOM case, has said that when citizens have legitimate questions about the propriety of state action and its consistency with the Constitution, these should not be turned away. Democracy is nourished by posing the questions, by the court answering them. He also, in giving the majority decision in McEwen in 2018, sketched out some of the contours of a democratic culture. He named gender stereotypes, which are telling us who we can be, as corrosive to equality and antithetical to our self-determination. The majority concluded that our right to express ourselves is a cornerstone of our democracy, and to interfere with that right not only stultifies the human spirit, but it retards our social progress. His majority decision also added that it's essential to human progress that contrary ideas and opinions peacefully contend. Tolerance must be cultivated, not just for the sake of those who convey a meaning, but for the sake of those to whom it is conveyed. Secondly, I want to think through for a brief minute what the CCJ seems to be suggesting to us about democracy and self-determination through its controversial Savings Law Clause jurisprudence. The Privy Council has said in several cases, most recently in the Trinidad and Tobago case of Chandler, that we don't particularly like these Savings Law Clauses, which you have in your Bills of Rights, but they're a part of your supreme constitutions. These clauses, many of you know, create exceptions to the supremacy of the rights regimes for laws which were in place before the constitutions came about. The Privy Council has said we can't will away these clauses through constitutional interpretation. If you want to address these clauses, complain to the right branch, which is Parliament, not to the courts. The very different CCJ approach asks and problematizes what we mean by democracy. The emphasis I hear from some of the court's language is that democracy must import the idea that we are self-governing, engaged in the practice of self-determination. Yale law professor Robert Post describes democracy in this way. He says, I think of democracy as the practice of self-government. It requires that people have a warranted conviction that they are engaged in the process of governing themselves. He says, the distinction is between making particular decisions and recognizing particular decisions are your own, the kind of idea which Simeon McIntosh had. Self-government is not about the authorship of decisions. It's about the authorship of decisions, rather, not about the making of decisions. Here is what Professor Poe says. Democratic forms of government are those in which the laws are made by the same people to whom they apply. But what the CCJ has said in a collection of decisions that it treats with suspicion the overwhelming impact on the dignity of Caribbean people of laws which were not made by the same people to whom they apply. They have read down the Savings Law Clause in Barbados, much the same way the Privy Council has read down ouster clauses in Trinidad, Tobago, and Thomas and AG, by giving it temporal closure that they say is consistent with the democratic values of a Caribbean people 60 years after independence. Turned upside down the notion of living constitution, they say or decolonization constitutions must change in their meaning over time. Similarly, in Richardson, the CCJ says that Guyana authored the decision to introduce term limits, and those reforms had the warranted conviction that Guyanese were engaged in the process of governing themselves. Finally, I want to say that I read in the praxis of the CCJ and its reasoning the enabling and encouraging of a constitutional dialogue as acts of collective self-determination. The detailed methodology recommended in the GCOM chair case was one of saying, how can we, notwithstanding our differences, make decisions collectively and have that warranted conviction that we're in the process of governing ourselves. In the McEwen case, where the CCJ declared an 1893 vagrancy law as unconstitutional, it made it an offense for a male to be dressed in female attire for an improper purpose. The CCJ, apologies, in legal terms declared the law void. But interestingly, the Assembly in Guyana went on with much ceremony to repeal the already voided law. So ignore my loyalist cynicism for a moment. What was happening was a dialogue between the court, its decision, the Guyanese legislators, and very importantly, the very persons who had been criminalized under the law. In the 2006 CCJ decision in Joseph, we hear the CCJ beginning to develop a jurisprudence on the death penalty. A decade later, it confronted frontally the Savings Law clauses in the Barbados Constitution in Nervée. In between, the Inter-American Court also had significant rulings, and over time, in the follow-up to these decisions from the CCJ, the Inter-American Court, Barbados signaled it was ready to amend its constitution to address the problem of the Savings Law Clause, and it did. The Constitution Review Commission, which issued its report last year, has honored the trajectory of that dialogue, of which the CCJ was an integral part, and has closed the chapter on the Savings Law clauses, which have dogged us for decades. These dialogues offer another orientation of this important court that judges, but also engages in dialogue with others, and dialogue which includes other judges through the forum of CAJO, for example. You've heard me cite President Saunders often today. My old teacher, Albert Fiaggio, would say he's in the departure lounge. He has had a sustained, wide-eyed attention to the Caribbean context in judging our democratic malaise, ascertaining what is the duty of the court as one scholar puts it, our constitutions call for democratic governance, but we lack a democratic polity. From Benjamin, when he sat as a High Court judge in 1998, to BCB Holdings in 2013, and McEwen and Richardson in 2018, there's a remarkable and consistent attention by him to democracy as a labor. He says democracy is not a state of bliss that a society effortlessly attains and in which we then forever bask. Democracy must continually be struggled for and nurtured and ennobled if it is to retain its efficacy. As I end today, permit me to briefly acknowledge the 20th anniversary of the establishment of this court and the leadership of its 3 presidents over these 2 decades. The late, the Honorable Mr. Justice Michael de Labastide, Sir Dennis Byron, and President Adrian Saunders, who has been, to my knowledge, the only judge of the CCJ who has served over all of those 20 years. I learned of the possibilities of a forward-thinking regional court before 2005. It was from seeing President Byron leading the Eastern Caribbean Supreme Court. And it's no accident that 2 Chief Justices of that court have gone on to lead the CCJ. Permit me to also say a few words about President Saunders as he waits in the departure lounge and Justice Anderson gets ready to lead. My analysis today around the CCJ as a guardian of democracy is in part a tribute to the CCJ he has led. I've wondered if his very brief moment in a Vincentian political party better oriented him to grapple with some of our democratic shortcomings. As I've said on another occasion, there is remarkable consistency to the kind of judge he has been since 1996. Consistency in his open-mindedness, his cosmopolitanism, his forward-thinkingness in imagining justice, peace and development in the Caribbean, his lack of pretension and accessibility, and his deep abiding love for the Caribbean and for its possibilities for self-determination. I'll continue to describe Justice Saunders over and over again as a judge who met the moment in the Caribbean, from the attack on freedom of expression in Anguilla to the predicament of harmful colonial laws in constitutional frameworks with savings law clauses, to the acute political crisis in Guyana, to the mandatory death sentence in the Eastern Caribbean. He has an unashamed ambition for the Caribbean. He sees through his leadership through building ideas. He also sees through his leadership building institutions. He has contributed to the CCJ's reputation for independence and accessibility. And he has done so with a strong investment in strengthening all judicial institutions across the Caribbean and its officers. Finally, he has been bold in placing the values of respect for difference and diversity, self-determination as political necessities and essential to meaning-making for our lives in the Caribbean and our communities. He has refashioned our constitutional vernacular through his value-rich framings and his commitment to judging as part of the struggle for democratic polities. As we celebrate the court's 20th anniversary, I acknowledge all its staff, its judges, past and present, the members of the Service Commission, and I particularly today offer my sincere thanks and appreciation to its 3 presidents. Thank you very much.
It is without doubt that that was a brilliant lecture. Please give it up once again for our professor, Professor Tracy Robinson. I am sure that based on the lecture that everyone here would have heard, that there are some questions that may be posited, and as such, we're going to open the floor to a question and answer segment, right? So we're going to invite anyone here who wishes to ask a question. You may do so. Anybody? There will be 2 roving mics around the audience, so just raise your hand and one of our ushers will. Okay, great.
I just wanted to find out what particular step Barbados took in relation to the savings law clause.
Professor Roberts.
Because here again, it looks like Barbados is leading us.
Are you
At least they
coming?
have done something.
You want to
I want to know what it is that they did.
So they amended the Constitution. It wasn't an entirely full removal, but the effect of it was full. And so the General Savings Law clause after that amendment had no significant role to play in limiting judicial review of colonial laws. More importantly, I think the Constitution Review Commission has maintained that stance and has not turned backwards, as we did in 2011. And it has clearly signaled that the provisions in the Barbados Constitution are designed to give full effect to the rights. And there are no savings law clauses of the ilk we have lived with for 60-something years in the proposed new Barbados Constitution.
All right, any other questions? Well, we're taking one more. Yes.
I want to cheat and go with you. Oh, thank you. I didn't know I would get a mic. I ought to stand, I hear. Good evening again, everyone. Okay, you can hear me? Okay, great. Professor, I wanted to ask, would you agree that it is the Westminster style that encourages this tenuous relationship with democracy? And if you agree that it is indeed the Westminster style that's the issue, how would acceding to the CCJ solve that issue?
So you acknowledge that you also want to think about reform.
Yes.
So there's no question that we have been talking for decades about Westminster, and in fact, some people call it Westminster. I think there's also an acknowledgement that it could be strengthened, the system we have. The sense I have is that many of the reformers around the Caribbean, including Barbados, want a fairly similar system to what they have. But that said, I also think questions arise as to what our current constitutions mean, because they aren't entirely explained by what happens elsewhere. And I think the answer which you hear from Justice Witt is even if we did follow elsewhere, that does not tell us what the values which are embedded in those principles should be. And so that's how you saw the Privy Council in the case of Chandra Sharma had to proceed. It says, well, what are the values in this constitution? Westminster can't help me. The value is there must be some even-handedness in the partisan political system so that we don't have a situation where one set of folks sitting on one side of Parliament are being paid and can pay their rent and children's school fees, and the other, who are part of the incumbency, are in the other side, the opposition, are in a totally different position. And so somehow you have to ask, what are the norms, the values? That's what I heard Justice Witt asking. That's what I think the CCJ has been doing over the last 10, 15 years in trying to figure out through a matter of constitutional construction, what are those values? Yes, we see the gaps. The Privy Council is correct, there are gaps. We see the gaps, but how do we figure out what should fill those gaps?
Thank you.
Thank you so much, Professor Robinson. And that is the end of our very short question and answer segment. At this time, I am going to invite, though online, the Honorable Mr. Justice Adrian Saunders, the President of the Caribbean Court of Justice, to make remarks. Please make him welcome.
For organizing this wonderful event. I deeply appreciate the very studied analysis and extremely generous comments expressed by Professor Tracy Robinson. All the more so because I regard her as the foremost constitutional law academic in the Caribbean community. I am truly humbled. I prevailed on acting principal Greenaway to permit me to exceed my originally allotted 5 minutes, but I still hope to be brief. As has been observed, this year marks 50 years since the region has been producing its own homegrown lawyers. And today, this very day, we celebrate 20 years since the glorious inauguration of the Caribbean Court of Justice. To celebrate that event this morning in Port-au-Spain, we held an interfaith service of reflection, and in the afternoon, the judges and staff of the court engaged in an intimate huddle where we gave thanks, we relaxed, and we looked back with pride on the last 2 decades. Today has been that kind of day for us, one of introspection and reflection, seeking inspiration and giving thanks. The establishment of the CCJ is, in my view, the most far-reaching, the most consequential decision ever made by the political directorate of the Caribbean community. I've heard it compared to the establishment of the West Indies Federation in 1958, but I disagree. That ill-conceived creature was always likely to fail. It was a construct devised by Whitehall in a manner to palliate restive West Indian nationalism. It was a colonial entity whose Governor General, Lord Hales, was a British public servant in whom was vested all executive authority within the federal government. On the contrary, the CCJ was conceived and entirely constructed by us with input from the Caribbean people, and in particular from the Jamaica Bar Association. The CCJ is an authentic, autochthonous vehicle designed to advance democracy and the rule of law in the Caribbean community. It was primed to succeed, and it has been precisely fulfilling that destiny. And so today, I give thanks to the leaders and the governments and the people of the Caribbean community who supported the establishment of the CCJ. In particular, I give thanks to the states of Barbados, Guyana, Belize, Commonwealth of Dominica, and St. Lucia for fulfilling their treaty promises and for entrusting to the court the solemn responsibility of deciding their final appeals. I wish also especially to recognize and to give thanks for the noble efforts to subscribe to the appellate jurisdiction of the CCJ made by the Grenada government of the Honorable Keith Mitchell. The valiant endeavors of Prime Minister Mitchell, his government, and the Parliament of Grenada were thwarted on each occasion by an independence constitution that imposes extraordinarily high referendum requirements on Grenada. Twice, the patriots of that country tried to accede to the CCJ. And even though on each occasion, 100% of the government and 100% of the parliament were in favor of the CCJ, they were stymied by those steep referendum requirements. The Antigua and Barbuda government of Prime Minister Gaston Brown also valiantly tried, but his government and the parliament were also frustrated by similarly high referendum thresholds. The Jamaica government of Prime Minister P.J. Patterson and the Jamaica Parliament of the day also attempted to subscribe to the court's appellate jurisdiction, but those attempts were also successful. Nevertheless, I wish to thank the leadership and the governments of all of these states that tried unsuccessfully to repatriate from London the full responsibility for their own jurisprudence. I thank them for their courage and conviction and their unyielding solidarity with the Caribbean Court of Justice. I have just returned from the Commonwealth Law Conference that was held recently in Malta. While there, I attended a very spirited panel discussion essentially about the relevance and utility of the Judicial Committee of the Privy Council. I was initially minded not to contribute to the discussion, but I felt compelled to do so after listening to the Deputy President of the Privy Council, who was one of the panelists. Among other things, the Deputy President repeated the view that the Privy Council was, quote, immune from political pressures, unquote, thereby implying that the CCJ and all Caribbean courts were perhaps not so immune. The Deputy President's statement was a repetition of one made by the Privy Council in a judgment issued in 2005, when a direct comparison was made between the Privy Council on the one hand and the CCJ on the other. The unfortunately drawn comparison actually played a factor in the reasoning that overturned the acts of Parliament that had been passed by a sovereign Jamaica legislature. Those acts had been reviewed and approved by all the judges of Jamaica, both at the trial and appellate levels. After the Deputy President made his statement, I felt obliged to take to the podium. Now, let us pause for a moment and do something it is often useful to do. Let us look to our literature and to our history. The great Caribbean writer from Barbados, George Lamming, once said this about our pre-independence journey. These are his prescient words, not mine. British colonialism, he said, and I quote, was not a physical cruelty. Indeed, the colonial experience of my generation was almost wholly without violence. No torture, no concentration camp, no mysterious disappearance of hostile natives, no army encamped with orders to kill. The Caribbean endured a different kind of subjugation. It was the terror of the mind, a daily exercise in self-mutilation that was the breeding ground for every uncertainty of self. I recall these words of George Lamming whenever I hear the statement that the Privy Council, unlike the CCJ, is immune from political pressures. Immunity from political pressures emerges not from a court's geography or physical distance from the site of a dispute it is resolving, but rather from the institutional framework that supports the court in question, from the method of selection of its judges, and from the personal integrity of those judges. I took to the podium in Malta to prevail upon the Deputy President, please, to refrain from making statements that suggest that, unlike the Privy Council, the CCJ is not immune from political pressure. Such statements are wholly unsupported by evidence. They are grossly unfair, and when made by a member or supporter of the Privy Council, they are manifestly self-serving. It is an internationally well-recognized fact that the architecture that supports the CCJ's independence is second to none, unmatched even by the Privy Council itself. And so far as personal integrity is concerned, it is a grave slander on my colleagues, on all who have served on the CCJ, and on me to suggest that our integrity is somehow lesser than that of the judges of the Privy Council. the continuous repetition of statements that openly question the integrity of Caribbean people, specifically of CCJ judges, and any interactions we may have with Caribbean politicians, precisely falls into the category of that to which George Lamming was referring. The most regrettable thing is that not a few otherwise responsible persons up and down the Caribbean, including some lawyers, and ironically, even a few Caribbean politicians, mindlessly repeat these false statements. What results is a self-mutilating mantra that has zero evidence to support it, and which goes some distance to cultivating among our people every uncertainty of self. Interestingly, statements questioning judicial integrity have never been aimed at the judges and politicians of New Zealand, for example. Or take Malta, where the deputy president made his remarks. Malta is an island in the Mediterranean so small that it will fit comfortably in one of Guyana's rivers. Both its population and its land size are less than those of the parish of St. Andrew in Jamaica. Malta left the Privy Council to establish its own final courts in about 1973. They did so without a fuss. I've never heard it said of Malta's judges and Maltese politicians what is repeatedly said of the Caribbean and of Caribbean judges and politicians. The world is becoming a more and more dangerous place for the peoples of small states. These are times when we must keep our wits about us and neither encourage nor succumb to terrors of the mind. Caribbean people cannot afford to persist in self-mutilation. Instead, we must resolutely embrace and act out Brother Bob's famous emancipation injunction. We must bring ourselves to accept the self-evident truth that the most appropriate court to hear United Kingdom final appeals is a United Kingdom court. The most appropriate court to hear Malta's final appeals is a Maltese court. And without the shadow of a doubt, 50 years after we began producing our own lawyers, the most appropriate court to hear Caribbean appeals is a Caribbean court. Forgive me, I digress. This is a day not for recriminations, but for giving thanks. Today I give thanks that with the support and effort and goodwill of this law school and so many other institutions and persons in the region, the CCJ has passed with flying colors the tests that have been laid before it. We are not a perfect court. No court is, but we shall forever keep striving for excellence. Colleagues, ladies and gentlemen, I give thanks to you for your generous attention. Thank you very much.
And thank you, Justice Saunders. Really, really powerful words that were said by yourself. I think at this time, we are going to hear from one of our very own tutors, Miss Betton, who will be sharing with us a very special presentation. Please make her welcome.
Thank you very much. Good evening, everyone. All protocols adopted. It's really not a presentation, but it's more of an announcement to say and to recognize the occasion of 20 years, and that's the 16th of April, 2005, since the inauguration of the Caribbean Court of Justice. The Norman Manley Law School, through its research, publication, and legal education unit, is pleased to engage in a series of activities for the year starting April 2025 to March 2026. We will be adding to the noise, as Professor Robinson said, and we will be studying the noisy court as well. We will look and examine the judgments in the appellate jurisdiction of the Caribbean Court of Justice and its development of Caribbean jurisprudence. Our faculty and staff will be engaging in those activities, and we'll be highlighting these judgments monthly. We also have our lecture series, and this one is the first of others. And this one is a student-led initiative, and we'll have others led by faculty as well. Our library will be engaging in publicizing and highlighting the publications by and about the court. And I noted that Professor Robinson listed many, a lot more than I had highlighted here. We also, with the help of the students, will be launching our Ambassador Corps, and this is our way of sensitizing the work of the Caribbean Court of Justice and having our students lead that initiative. We'll be engaging also in mini-moods and quiz competitions. Another sensitization activity, we'll discuss the cases in the appellate jurisdiction. That was deliberate for us, that we wanted to highlight that we know a lot of work has been done in the original jurisdiction. We want to highlight the work in the appellate jurisdiction, especially looking at how it impacts on how we teach here at the law school in the different courses. So we'll have some lunch and learn activities. We'll also have a special clinic on the law and practice in the original jurisdiction of the CCJ. We will connect with the rest of the region, regional collect, learning from those countries, and Justice Saunders had highlighted those 5 countries that have acceded to the appellate jurisdiction of the Caribbean Court of Justice. So we will connect with advocates in these countries to share their experience on appellate advocacy in the Caribbean Court of Justice. We ask that you support all these activities as we roll them out over the year. Thank you.
And I can safely say, as a student myself, Ms. Benton, that I'm definitely looking forward to all of those initiatives that the law school will be engaging in with us as students forthcoming. So as we near the end of this distinguished lecture, I would like to invite some members of the lecture committee who are going to be giving some presentations to our guest speakers today, starting off, of course, with our distinguished lecturer, Professor Tracy Robinson, if you could join me up here, and Miss Opal Wisdom from the lecture committee will be presenting to you our token of appreciation for being able to come up here and edify us some more about the jurisprudence that is the Caribbean Court of Justice. Please, can we get some applause, please, everybody? Yes, love to see it. And following Professor Robinson, of course, we must make mention to Senator Donna Scott Mottley. And truth be told, I felt like your speech was more than just a speech, it was a charge. I think it was something that I can speak for most students, we really understood the meaning behind what you were saying. So if you may just join me here on the podium as well, please clap for her as well, guys. And this presentation is being done by Mrs. Olivia Porter Suter from the lecture committee as well. All right. Great, wonderful. So to bring this entire event to a close, I must give special shout out, as you would say, right, to this young woman who not only led the lecture committee with brilliance, but who was able to put together this event. And I must applaud her because she is someone who doesn't like to take praise very often, but I will be, giving her her flowers. So please help me welcome the chair of the lecture committee, Ms. Kemwe Perry, to give us a vote of thanks. Yes.
You like to embarrass me? No. Miss Eulalie Greenaway, Madam Principal Acting, Miss Whiteley, Senior Tutor, Registrar, Assistant Registrar, Professor Tracy Robinson, Senator Donna Scott Motley, Solicitor General, Justice Saunders, colleagues, the administration of the law school, students and friends, good evening. Good evening. Good evening. Oh, okay. As chairperson of this year's Norman Manley Lecture Committee, it is my distinct honor to offer the vote of thanks on behalf of us all. First and foremost, I extend our heartfelt gratitude to Professor Tracy Robinson for her masterful exposition on the Caribbean Court of Justice, a guardian of democracy and justice in the region. Your depth of scholarship, compelling examples, and inspiring vision have reminded us all why our regional court remains a cornerstone of Caribbean unity and rule of law. Thank you for sharing your time, your expertise, and your passion with us today. To Senator Donna Scott Motley, we owe a special debt of appreciation for your thoughtful and incisive reflection. Your remarks illuminated the life and work of the Honorable Norman Washington Manley. It is truly a blessing when we are able to learn about those who came before us and just how steady the shoulders are upon which we stand today. Our sincerest thanks to our performance, Lehana Sachel, Mr. Joel Taylor, and who you'll hear later on, Mr. Sean Vassiani, whose musical contributions added warmth and inspiration to today's program. You have uplifted our spirits and punctuated our proceedings with beauty. This lecture would not have been possible without the dedication of our lecture committee. Allow me to acknowledge my vice chairs, Apoy Robinson and Opal Wisdom, whose steady guidance helped steer the planning from start to finish. The secretaries, Mr. Savion McFadden, Suzette McNabb, whose tireless attention to detail kept us on schedule and on message. The graphic designer, Mr. Shamar Crossfield, whose striking artwork and visual materials captured the dignity and spirit of today's proceedings. To each committee member and usher, I say thank you. Your courtesy, professionalism, and warm smiles ensured that every guest felt welcomed and well cared for. To the audiovisual and technical support team, Mr. Cousins, Mr. Pinto, Mr. Scott Reed, Mr. Morgan, Mr. Montague, your work did not go unnoticed, and your attention to detail shows just how much care and thought you have put in your work. And for that, we thank you. Extra commendations must be given to Madam Principal, Ms. Greenaway, Assistant Registrar, Ms. McCarthy, Ms. Betton, and Ms. Phillips. Even though I took the phrase thorn in the side of man literally by calling you guys every hour of the night, you guys did not turn your backs on me, and for that, I'm appreciative. To the leadership and staff of Norman Manley Law School and everyone who supported this lecture behind the scenes, thank you. Your belief in our mission and your support of legal education and dialogue in Jamaica and across the Caribbean made today possible. Finally, thank you to all of you, our audience, students, faculty, practitioners, and friends who have honored us with your presence and participation. It is your engagement that truly brings life to gatherings like this, and we trust you leave inspired to uphold the values of democracy and justice in our region. Ladies and gentlemen, on behalf of the Norman Manley Lecture Committee, I thank you all. We look forward to welcoming you again next year. Please enjoy the cocktails outside, and again I say thank you.
And with that, we have come to the end. My name is Savion McFadden. It has been a pleasure being your Master of Ceremonies for this lecture. As Ms. Perry rightfully mentioned, at this time, you may now proceed to the foyer for cocktails.